This is a data privacy detective. Well, it's May of 2024, and we're going to look back at the month of April with my good friend and colleague in law and otherwise in data privacy matters, Yugo Nagashima. Yugo, thank you for joining us as always in this monthly review.
Thank you for inviting me again, and it's always good to be here.
Well, Yugo, you are a partner in the coast-to-coast law firm Frost Brown Todd's data security and privacy team. And we're going to talk about three interesting things that have really come up in the month of April 2024. So let me kick it off by, well, what is the APRA? It sounds like the AARP, but what is the APRA and why is that in the news?
Yeah, so like the AARP, it's the company that, when you have your car breakdown, no, I'm just kidding. It's American Privacy Rights Act of 2024, which is a federal bill that I want to point out that is currently being circulated in the committee, in the House committee, I believe, or the Senate committee, which may become federal comprehensive privacy law.
May or may not. Now, predicting that Congress is going to act, now that's pretty bold, so we don't know. But who's behind it? I mean, is this bipartisan, one side or the other aisle? What's going on?
When you look at the law, it does look bipartisan, but there are a lot of controversial items that I'd be happy to discuss with you here.
Yeah. What are they? What are the big questions here?
So big ticket items, if you remember back in 2022, there was also a bill for a comprehensive federal data privacy law. There were issues, and the two issues were the having or not having a private right of action and preemption. And again, the APRA has both of them included in the bill.
Now, this is interesting. Now, I think it's true now that a majority of nations, depending on how you count them, now have a comprehensive national data privacy code, and we don't in the United States. Now, we have it maybe for HIPAA, for medical stuff, and the financial sector is pretty well, but no comprehensive code. So that's what we're talking about here. And you mentioned preemption. So talk a little about that.
Sure. So the concept of preemption is, for those who are not from the United States, let me just briefly talk about it. In the U.S., we have the federal law, which is, the central government law, and then there's state laws. And when we usually talk about the U.S. privacy laws, we talk about the state laws, like the California Consumer Privacy Act or the Virginia law. And when you have a state law and if you have a federal law, which one supersedes or which one controls? That's the issue of preemption. And preemption means that the federal law would supersede the state laws.
And that's often what happens. Sometimes we call the U.S. system, federal system, laboratory, where the states experiment for a while, and then pretty soon things get pretty much clear, and then the federal government comes in and says, okay, for good commerce reasons, let's have one law that applies to everybody. But other times it's different, isn't it? Such as we don't have a national civil code the way many civil law countries do. So what's as it applies to data privacy? What are the issues about preemption?
Sure. One of the bigger issues is if there's a federal data privacy law, and if that preempts all the state laws, from the state legislature's perspective, even if the states have a more consumer-friendly data privacy law, right? If preemption happens, then the general, the less consumer-friendly federal law controls, and certain states and certain, congress people or a congressperson are concerned that the federal law can exist, but why can't a more consumer-friendly law, for example, the CCPA, ultimately control important issues that are more consumer-friendly?
Good point. And now we won't have time now to talk about this law in enormous detail, and it's not a law yet. It's an act bouncing around in Congress. What are the other big things here? I'm sure big tech has its lobbyists at work here, and privacy-centric NGOs are hard at work and so on. What are the big issues beyond preemption?
It's the private right of action or the private cause of action.
Yes. Can individuals sue and collect money about this? That's what this is about?
It is. And so far, if those who follow U.S. state privacy laws, we haven't seen much of the private right of action. I guess except for a minor aspect in the CCPA and the Washington My Health, My Data Act.
Illinois has one in biometrics.
Right.
By and large, the state codes will kind of leave it up to the attorney general or regulator.
Right.
Yeah.
But the APRA gives a private right of action for violations of the APRA. And not only that, I want to add, if there's an arbitration clause, right? Let's say there's somehow, on the website, there's an arbitration clause that says, well, there's you have to go to arbitration. This arbitration clause is basically knocked off, if the plaintiff claims that there's a substantial privacy harm of over $10,000, or there's a specific physical or mental harm. And again, people can allege this, right? So arbitration is off the books. And you know what this means, right, Joe?
Yeah. What does it mean?
It means class actions.
Class actions, yes. Some lawyers will be maybe all lawyers will be happy. But companies won't be. And the federal courts, this will be a federal law. Federal courts, they're not going to be real pleased. I'll need more judges. So what's your prediction? This is going to pass?
I don't think in the form that it currently is, it will pass. I think there'll be modifications, especially in the private right of action. I also think preemption may change. And again, this is an election year. This law, is in the committees, but as time goes on and with the election heating up, I think there are other items that both the House and the Senate, the House meaning the House of Representatives and Congress and the Senate, will be concerned. And I think it really depends on how quickly the law can pass through and get amended and changed to become a federal law.
Good point. And probably by the end of this year, most people expect at least half the states will have a comprehensive state code. So we'll see how it evolves. But thanks for the review of the APRA. It's worth following. And if for no other reason, we'll really see what the battles between big tech and privacy advocates and others really are in the halls of Congress. Well, let's turn to the state of Maryland, which in April adopted the Maryland Online Data Privacy Act of 2024. Another state with its comprehensive code. Now, it's before the governor who's expected to sign it. We'll see if Governor Moore does or not, or sends it back for more work. Don't know. But what does it do? It applies to a person that conducts business in Maryland or provides services that are targeted to Maryland residents. That's what state codes have to do, of course, with certain limits. A certain number of consumers have to be involved. And it has a number of exemptions, such as for financial institutions, data that's covered by HIPAA. So this is a little bit like the reverse preemption, saying, okay, we got a federal code on this. We don't need to deal with it as a state. It's kind of interesting. And it applies to controllers and processors. There are restrictions on those who collect personal information and those who process it. But there's a ban. Now, this is where it gets really interesting. There's a ban on the sale of sensitive data. Now, what's sensitive data? Well, personal information that would reveal racial, ethnic origin, religious beliefs, health data, sex life, sexual orientation, statuses, transgender, non-binary, national origin, citizenship. A lot of things about us are sensitive. It includes genetic and biometric data. So it's quite broad. It's expansive on what biometric data means and what sensitive data means. And there's an outright ban on the sale, meaning even if it would be consented to a certain extent. And sale doesn't just mean, send $9.99. It can mean an exchange that allows people to be identified by these sensitive data as long as the disclosing entity is revealing it for some consideration. Doesn't have to be money. And that's one where high tech has really gotten involved here. You can imagine Yugo, high tech. Wait a minute. Even if somebody wants to sell their sensitive data, they can't in Maryland. You're going to hear this. Let me pause there for a minute. What are your thoughts so far?
Right. So as you note, the sales sometimes may happen because the individual will allow for it, as you noted. If the individual consents to it, it may be beneficial to the individual, and we can probably think of certain situations like that. And not only that, it's for valuable consideration, right? So what is valuable consideration? And it's like you said, it's an exchange, right? It's a bargain for, but it's really unclear. At one point, does it become a sale? And that mostly will be litigated in the future. But an outright ban just seems to be very limited because, Joe, I believe you gave an example. You said that if a church publishes information about its members of
a directory of the congregation with photos and call, which people in a church would like to do that, send cards to one another, or a synagogue or a mosque, but that identifies their religious affiliation.
Right. How do you, and the individuals say, well, sure, because I want other people in the congregation to know, but the law from the state says no, so it can no longer be sold. Maybe the solution to that is just, publish it online. But again, then what's the difference here, right? What's the difference between publishing it online or selling on paper so that people who really can't access the internet, people who may not have the money or the people who may not be so tech savvy, they're stuck. So there seems to be some missed opportunities to consider how to manage and control the sale of sensitive data. I think the principle, it was, with very good intentions, but given how broad it is, it might cause issues in the future.
Yeah, we'll see what happens. If it goes into effect, their data protection assessments to be done. Now, this is very much like what we see in some state codes, and certainly GDPR requires a kind of risk analysis, and you see this creeping now into state codes like the ones in Maryland about what really creates a heightened risk of harm to consumers. Interesting, a little different approach for children. This act that's been passed prohibits controllers from selling personal data if the controller knew or should have known the consumer is under the age of 18, not 13 or 14 or 16. Well, that's interesting. But it does allow for the opt-in of processing and sale of minors' data on restricted basis. So this will get interesting. There are typical notice requirements giving individuals a notice about what their rights are. They're not. It's not to be used to discriminate against people by using personal data. That's an emerging topic one often sees. Consumers have various rights to opt out of processing that they don't like, and get a list of categories for who's getting the information when somebody collects it, things like that. It's not atypical from what you see in a lot of states. And it's going to be enforced, though, by the Maryland Division of Consumer Protection with the Attorney General's participation. And it doesn't expressly and specifically provide consumers with a right of action that you talked about, Yugo. That's certainly a hot issue in the Congress. If it is signed by the governor, it'll take effect October of 2025.
So, Joe, I do want to add one point with the enforcement. Unlike some other states like California, which took away the right to cure, the Maryland law appears to have a right to cure provision, right?
Yes.
Yeah, and I think that is one of the saving graces, because without a right to cure, you're right into enforcement.
Well, that's exactly right. Now, having said that, some of the headlines and some of the privacy promotive NGOs and organizations give very high marks to Maryland, that Maryland is bravely risk the rage of the tech giants, because they're certainly not happy about a ban on sale or exchanges of much of anything. And they'd rather have opt-out instead of opt-in and all these kinds of things. So, but Maryland went ahead and did it, and they gave Maryland a very good mark. Many states get an F from privacy-centric organizations because it's sort of following the lobbyists for the tech industry's standards of creating some protections, but not overdoing it the way a lot of the tech giants view GDPR. But if you're ready, Yugo, let me turn to this one. Here's my question.
Sure.
What do Schremms, AI, and birthdays have in common?
I know the answer to this one.
Oh, what is it? What is it?
The alleged GDPR violation.
Of all things, what's this about?
Yes. So just recently, in the last day, I believe, Max Schremms, or his organization NOYB, has filed a complaint with the Australian Data Protection Authority.
Austria,
right?
Yeah. Part of Europe.
Pronunciation is bad. Yes. That ChatGPT has violated Mr. Schremms'.
Now, wait a minute. A chatbot is getting in trouble under GDPR. Now, what's going on here?
Okay. So apparently, Mr. Schremms entered a prompt asking ChatGPT to tell him what his birthday was.
Maybe he forgot. Go ahead.
And maybe he forgot. And ChatGPT returned the wrong birthday.
Uh-oh.
And this happens, right? And I want to explain a little bit of a concept of artificial intelligence applications. And sometimes the data that's being crunched by the AI in its algorithm will hallucinate and provide the wrong answer. And AI may be, this wonderful tool that you can use to, write briefs and everything and even pass the bar. But sometimes to get the information wrong, and this was one instance where Mr. Schremms' birthday was apparently not correct. So
amazing. And so what? This is a little weird. It's talking about his birthday, which is probably public somehow. And, but so what remedy would there be, or how does GDPR get involved?
So Mr. Schremms said, well, my birthday is personal data under the GDPR, which is true, right?
That's true. It is. Yeah. It helps you identify someone. Okay, fair enough.
And he said, well, it's wrong, so I should be able to rectify it.
The right to correct inaccurate data. Well, that sounds like he should be able to do that, right?
So, exactly. So he reached out to OpenAI, which is ChatGPT's company, the company that runs ChatGPT, and said, hey, can you please correct it? Mm-hmm. And the response that Mr. Schremms got was, well, we're working on it, but we really can't do anything about it because, it's an algorithm and it's doing its thing. Essentially that, the research is being taken so that, the correct and accurate answers can be provided, but the right to correction cannot be exercised, essentially.
Well, if you think about it more broadly, I mean, algorithms are one thing, but the database is a huge database of published information, some of which can be right, some of which can be wrong, some of which can be deliberately wrong. Who knows? But you're saying that if Schremms is right about this under GDPR, then anybody can correct any personal information about them, even if data is being provided to the database is not being made up by ChatGPT. It's a mass of data coming from everything people put out there.
That's right. And just to make clear, what Schremms was really trying to do is to say, can you please block my data if it's not correct? And again, like you said, well, it's using a large database, and whatever the algorithm crunches from that database is what the algorithm crunches and returns an answer. So OpenAI said, no, can't do it. And like you said, it's very hard to unteach an AI algorithm, right? And the data set is the data set. They can modify it, but blocking it was something that apparently OpenAI was not open to, even though their company's name's open, no pun intended. And Mr. Schremms was very annoyed that he decided to file a complaint.
One could make a bit of fun of this because, as I understand it, Mr. Schremms has published his birthday. I think he said it was October 1. Hope he doesn't sue me if I get it wrong, and all he has to do is let me know, and I'm happy to correct it. But more deeply, this is a real challenge to AI, isn't it? Because, I mean, AI is not a judge. It's an amasser of data coupled with algorithms that then give an answer. Let's say the algorithm predicts someone has cancer based on some information. Let's say that turns out not to be true, but in some ways, it's more probable than not. I mean, this could really disrupt what AI is all about, couldn't it?
It could. The problem is, under the GDPR, especially the right to correct or having accurate information, Article 5.1(d), it does give the data subject the right to correct information. And it is true that ChatGPT does have that personal information.
Yeah.
So this is something for the Data Protection Authority to sort out, and potentially the European Union's courts to sort out. It will be interesting to see what happens, but it does pose a large issue because, again, AI algorithms, it's not easy to unlearn something that's wrong, right? It's something that researchers are still working on, and that was a response by OpenAI. But Mr. Schremms does have a point that he has a right to correct. Who wins? Which, does the technology overrule the right, or does the right should always be guaranteed? It'll be a difficult question for the Data Protection Authority and ultimately the courts to decide.
Well, it sure will. And unlike the United States, the European Union does have a fundamental right in its constitutional documents for personal privacy.
That's
and
right.
So what it means and how far it goes, and if the right to be corrected, that seems like an easy one. How about the right to be forgotten? The right to say, please delete this data about myself. How do you delete yourself from a published database from millions of people? It will be truly interesting. Well, Yugo, any concluding thoughts on the month of April?
The month of April was a blast, as you can see. A lot of development in the United States, very fun development in the last 3 days from Europe, and privacy is just getting more exciting and exciting in 2024. We will continue to follow it, and we'll update you again.
Well, thanks so much. And as always, I'll conclude by reminding us all, protecting your personal privacy begins with you.